Hot powers, here's one of the big changes in the powers of attorney that you will see drafted after January 1st. Many powers in the document you will now need to expressly grant, or your agent will not have the authority to use these powers. In the past, you had some of these powers by default. However, there were cases of financial abuse through the use of one or more of these powers, so now the legislature requires you to choose whether you want them in your document. The drafters are informally calling these hot powers to signify the importance to the party granting them. There are 8 such powers. I'll tell you about 4 of them. First of all, to make a gift. This has actually been a hot power since 1998. If you want somebody to give your money away, or even take your name off an account, or perhaps a piece of real estate, and this could be your wife, quite frankly, you need to give them the power to gift your property. And you need to define the amount of the gift. It could be a very limited amount, or it could be an unlimited figure. And you want limitations on the power as to who they could give your property to. Maybe it's just your wife and children, those in your estate plan. You need to define that in the document. So gifting remains a hot power. To change or create a right of survivorship, such as a bank account. This goes on all the time. Most banks are aware that kids come in, they want to put their name on mom or dad's bank account. Well, from January 1st forward, you're going to have that power in the document if you want to add your name to your parents' bank account. If the power is not in there, the banks are authorized to say, no, you don't have the power to put your name on a bank account. To change a beneficiary designation, like in a life insurance policy, who will inherit the money in this policy at your death? Powers of attorney were authorized in the past to change beneficiary designations. Now you've got to affirmatively decide whether you want that power in the document and how the authority will be granted. To anybody at all? Do you want it in accordance with your estate plan? You've got to spell it out. To create, amend, revoke, or terminate a lifetime trust. Trusts are estate planning devices, and the reason for creating them are very many. But in the new law, you can now authorize your agent in your power of attorney to create trusts for you of any kind and under any terms that you decide. So as you can see, these are rather powerful tools. They're often used in the estate planning world. The law goes on to restrict who can actually use these hot powers to close family members. But you can opt out of this provision and allow anybody to use these powers for you. All of the powers of attorney drafted after January 1st will need to expressly grant these powers. If you don't do so, you will have a very conservative power of attorney that will restrict your agent's ability to engage in estate planning on behalf of you.